Mr. Stevenson.
Good morning, Your Honors. My name is Charles Stevenson. I represent the defendant, Alexander Williams. As you know from reviewing the briefs at trial, the central focus of the case was the issue of self-defense, and unsurprisingly, that same issue is at the heart of this appeal. The central hub of the arguments I would present on Mr. Williams' behalf relate to the jury instructions, and to get it on the table immediately, it's very clear here that I'm swimming upstream, that there are a number of decisions that this court has issued over the last several years, which in essence could be said to defeat the argument I present. Nevertheless,
Mr. Stevenson, I will say, this has nothing about the argument, but your suggested language is quite clear.
That's and you know, genuinely, I mean, I take.
Did you serve on the Model Jury Instructions Committee? Pardon me? Did you serve on the Model Jury Instructions Committee? Maybe we'll just put you on, Mr. Stevenson.
Well, yeah, I would serve best as a committee of one, but nevertheless, I would suggest that the issue is a genuine one and an important one, and I appreciate this opportunity to try to explain my reasoning. At the outset, it would be great if I could pound on the table and say, well, it's a red herring, but there's a legitimate issue here about whether Mr. Williams was even entitled to a self-defense instruction, and I want to devote a little of my time to that issue. Point out right at the outset that the standard, of course, is that the evidence must raise a reasonable doubt as to the constituents of a self-defense case, and that, after all, that evidence ought to be judged with an eye toward the imperfections of human nature and our foibles and disabilities. The most important factor, I would suggest, in this case is geographic. We know the case or the incident occurred at night. We know that it was raining. We all, in our experience collectively, know how difficult and deceiving things can sometimes appear at nighttime in the rain. I would suggest, too, that while there was lighting in the area, there's a legitimate question about its adequacy. That may not be an inevitable conclusion to be drawn from the evidence, but I think a reasonable one. Most importantly, though, this incident occurred at the corner of, I think it was Lowell Avenue and Blue Hill Avenue in Roxbury. At the time, I mean, police officers, Mr. Hagan, the prosecutor, made the point, at least indirectly in his opening. Several of the police officers testified to it. It was an incredibly dangerous place at a dangerous time.
Don't we know more than that? We know that the victim was shot a number of times. Was it 4 times or 5 times?
It was 4 times. There was evidence that there were 5 shots.
He was shot in the back.
Yes.
We know that the defendant had on a bulletproof vest.
We know that we do.
And didn't the defendant say that the victim was running and I was shooting?
Yes, that's correct. And were it not for the fact, I'm not sure what page in my brief it's on, but I brought them as a visual. The police marksman, I mean, it's footnote 9. It's somewhere early in my brief. Were it not for these 2 articles that I cite and something that I want to talk about a little bit further, I mean, I don't think there is an argument. But this fellow that authored the articles, his name's Bill Lewinsky. He runs an institute at the University of Minnesota, Mankato, and it's called Force Science. And he has made a lifetime of studying the biometrics of police-initiated shootings. I mean, he doesn't come, he wouldn't appear as a witness, as I understand it, on Mr. Williams' behalf. But in drafting these articles for the police magazines, he explains the studies that he's undertaken, and they indicate that a person can turn from a threatening position to be fleeing in less than 2/100ths of a second. I think it's 14 hundredths of a second. I'm sorry, I misstated earlier, less than 2/10ths of a second. And that there's a disconnect between the visualization of this, oh, this person is turning and is no longer presenting a threat to me, and the time that a person can stop pulling the trigger, not just holding a trigger down. I mean, there's this claim, of course, that Mr. Hagan makes in closing, pow, 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 pow. You have to shoot. Well, police revolvers and automatic weapons work that way too. And the point, again, is that it can take as long as 6/10ths of a second, a considerable period of time, for the head to tell the hand, stop shooting that gun. Of course, what Your Honor suggests is important. It's very important, and it's not particularly helpful to Mr. Williams' position. But I would suggest, of course, that one of the shots was a lateral shot. And it's also clear, you know, one of the big centerpieces of the government's case was that, hey, the bullets appeared to be in a progressive line, as if Mr. Williams were running toward Mr. Jackson as he was turning and running away. That certainly is a reasonable inference that could be drawn. But the only evidence as to what happened at that precise moment was the statement that Mr. Williams gave the police. He doesn't say, hey, I was chasing him as he was running. It's entirely possible that he was moving the other direction himself, that he was, in fact, fleeing. It may not be the only inference that could be drawn, but it is a reasonable one. And Lewinsky also has studied the matter of, you know, we always hear about, well, they discharged to the rear about 30 degrees when those bullet casings come out of an automatic weapon. Of course, as a hand moves around during an incident like that, they can be discharged in any number of directions, and I think that therefore is a less than compelling piece of evidence. I think probably the best argument I can make, in addition to citing Your Honor's attention to the Lewinsky studies, is that Judge Mulligan, after all, a very experienced trial judge, thought that Mr. Williams was entitled to the instruction, and accordingly he gave it. In essence, my argument is that bookend instructions at the beginning and the end of the presentation of an issue like self-defense, which clearly occurred in this. It's cited right in my brief, the number of times Judge Mulligan said, well, this is a self-defense case. The government has to prove the case beyond a reasonable doubt. That's the North Star. It's up there. I concede it. It's there. I would, however, draw your attention to page 22 of my brief, case that was decided by this court about 30 years ago, when some of these issues were less developed than they are today, whereas instructions using a terminology of burden of proof have a technical cast and may well be obscure to jurors. Instructions telling the jury that they must find or be satisfied of a proposition which the defendant claims would readily convey to them in comprehensible lay terms that it was the defendant who was required to wield the laboring oar. I'm not suggesting here that Judge Mulligan used finding language. In fact, he used the model instruction, which has been approved by this court. But I would suggest that as is made clear in the brief, there are a number of reasons why the model instruction is, first of all, not immutable, and second, is in fact misleading. Bless you. misleading and needs to be reconsidered. At a policy level initially, I don't think it can legitimately be argued that the various statements that Judge Mulligan gave to the jury about the constituent elements of a self-defense case were anything but suggestive of a burden shift. He didn't say the word find, but when one says a person may not use force in self-defense until he has availed himself of all proper means to avoid physical combat, or an individual may use only sufficient force to prevent occurrence or reoccurrence of the attack, or put another way, the proper exercise of self-defense means that a person in the defendant's circumstances would reasonably believe, et cetera, et cetera. It's clear to me, at least, that those instructions convey implicitly that it's Mr. Williams and not the government who bears some burden to shoehorn his defense into those standards. Clearly, and I cite a number of cases, this court recognizes that inconsistencies are anathema in jury instructions, and that after all, the standard is that they should be understandable to a group of lay people. It's also true that the law does need to be stable. There's a great quote in the brief from Dean Pound. The law must be stable, but it cannot stand still. So I would ask the court on a policy level to recognize that there may really be a problem here. On the more pragmatic level, I would suggest that that what has happened here is that the instruction has grown out of statements that this court has made in reviewing the question, the threshold question in this case, too, was Mr. Defendant entitled to this instruction?
So out of an evidentiary concern comes language that gets grafted into the instruction.
Exactly, and that really, while it's difficult for me to articulate it in a very compelling way verbally, the court has said, look, these subsidiary instructions are important. That's why they're there. If they're important, they need to be right. And that they, after all, are the roadmap. If we only had to look to the North Star, we wouldn't have invented maps. We wouldn't have the problems of getting lost in the forest. That's where the jury does its work, among the trees in the forest. And I'm simply suggesting that the way the instructions are presently worded, that it at least suggests in a situation where it should do the exact opposite.
Yeah, but let me sort of pick up on your metaphor. There's a monster in the forest. Here's what the monster looks like. Avoid that monster. I mean, that's the way the self-defense instruction is sort of created. Here's what self-defense is. Here, and the Commonwealth has to prove that the defendant did not act in self-defense. I mean, I understand what you're saying.
Again, I've searched and searched and searched for the aptest metaphor, and bottom line is I haven't truly come up with it. But it does clearly suggest to me that there is an issue, and if I were playing the game of war with Ms. Thomas, she has 51 cards. I've got one. But you know what? I'm telling you, I have the ace of spades. And the ace of spades is look at this court's model instruction on criminal responsibility, which is voiced in the negative. The government must disprove X, must disprove Y. If they do, and of course it's in the injunction, the injunctive, but that's not the word I meant. disjunctive, excuse me, that they only need disprove one of three elements. I think probably it would be the same situation here. And in fact, I would direct your attention to the conclusion of Judge Mulligan's instructions when Mr. Hagan says to him, gosh, Judge, I thought your instruction was a little confusing, and really all we have to do is disprove X, Y, or Z. And obviously he was not making my argument, but he was making an argument that this court I can consider. If it's confusing and of concern to the prosecutor, you can well understand that it would be confusing and of concern to defendants. Again, there are a lot of spokes around that hub that I think are important to bring to the court's attention. Most of them center around my assertion, and made advisedly because, of course, in this case there was not a motion for new trial. I certainly know how to file such motions and have done so on a number of occasions, but it is my contention, supported most recently by a case from the appeals court, Commonwealth versus Leicester. It's 70 Mass Appeals Court 55, just decided earlier this fall, that when the record is clear on the question of ineffectiveness, it's unnecessary and perhaps even inappropriate to become involved in the process of filing a motion for new trial. The first of those points I want to make is trial counsel's omission to make an opening. That, after having stood up at the conclusion of Mr. Hagan's opening, it said, Judge, I want a mistrial because of concerns he had about the prejudicial effect of assertions that Mr. Hagan had made. The trial judge jollied him out of that almost immediately, but the point is it really is an important part of the process.
This is a case where Mr. Williams testified, right?
No.
He already...
His statement was introduced by the government. And, of course, I guess I'll skip ahead a bit because some of my complaints about Mr. Hagan, who I've gotten to know personally and is, of course, a wonderful fellow, but nevertheless, in this case, went, I think, beyond the realm of what's acceptable.
But I guess my point only is this. It seems to me it's a difficult argument to make that it's ineffective for a defense counsel just focusing on not to give an opening statement because of the issue of not knowing what you're going to do vis-a-vis the defendant testifying or not.
Well, I would suggest that it was clear in this case that the only possible defense was self-defense.
Well, but that might well be something where the defendant would testify to, isn't it?
It would be, except that it was, it's also quite clear. There are various sidebars and stuff along the way where Mr. Trial counsel says to the judge, I haven't been able to talk Mr. Williams out of testifying yet. It's still on the table. And maybe Your Honor's right, except does that mean that in all of those cases when defendants testify there shouldn't be an opening? I'm simply saying that it is a factor this court should consider. Let
me just interrupt you for 1 second on that. I thought that some of the first words out of your mouth were, there is a question here as to whether or not self-defense was even available.
In which case, why was there a defense at all? Why was there a lawyer there?
Well, that may be why you don't give an opening statement, is you wait and see how things unfold.
Well, again, things were going to unfold with this audio-visual performance that Mr. Hagan had put together that shines up on the wall. Question, answer, question, answer. They'd gone through the whole thing pre-trial. And by the way, of course, as I note in the brief, there were a number of points along the way when, or one in particular, where trial counsel acceded to removal of some really significant exculpatory evidence. So again, if were that my only argument, it would not be the least bit persuasive. But I think in the context, especially this lifting the veil that Mr. Williams had attempted to cast in front of the jury, Mr. Williams didn't do anything.
But that's
Mr.
the closing, that's
Yes,
the phrase from the closing.
I'm watching my yellow light
Okay,
and
sorry. I'm
hopping
sorry,
around
sorry.
somewhat frenetically, but that it was a completely unjustified assertion to make. He'd made the statement the first time the police talked to him. He made the statement 5 years, I believe it was, before the trial. He didn't delay this case, which was another issue that was raised after 27 years of never having seen the argument on 2 consecutive cases before this court, the justice delayed is justice denied argument. In any event, Your Honors, thank you for your attention on behalf of Mr. Williams, and I appreciate it.
Thank you, Mr. Stevenson. Ms. Thomas?
Good morning, Your Honors. May it please the Court, Ann Thomas for the Commonwealth. And with me this morning is Assistant District Attorney Patrick Hagan, which you've already heard was the trial prosecutor in this case. I'm not exactly sure where to begin.
Well, one place I could suggest, Ms. Thomas, is I just disagree with you that if it's a model jury instruction, there can't be a substantial, given that the judge's instructions select the model jury instructions, there is no substantial risk of a miscarriage of justice. We make mistakes, too. I mean, that can't be.
No, I guess my point is based on the case law so far, and the Whitman case is early, as recent as 2000.
That was a little different because, Whitman was, if you find the defendant was in, that's raising the whether or not there was an entitlement to a self-defense.
Okay, so you're seeing that as harsher. If I could, I think the best thing that I could do is maybe read from the judge's instructions, because he clearly stated more than once that the burden of proof remained with the Commonwealth at all times. And again, he's starting with to reiterate. So he said this more than once, and the fact that he ends with it, I think, is also, as Justice Spina was speaking about, again, brings it all together to say, to reiterate, where there is evidence the defendant may have acted in self-defense, the Commonwealth must prove beyond a reasonable doubt the defendant did not act in self-defense. If the Commonwealth fails to prove beyond a reasonable doubt the defendant did not act in self-defense, then you must find the defendant not guilty of murder.
Do you agree that it's better it would have been better to have phrased it the way Mr. Stevenson phrased it in his brief? Is to say it in the negative,
those propositions,
right from the beginning.
That's on page 26.
I believe it could be helpful, but again, in this case, we're again talking about whether or not the defendant was prejudiced by possibly.
Sure.
Yeah, it's a different question, but
Okay.
you don't, do you have, just taking the language that Mr. Stevenson has suggested.
Yes.
Quite apart from whether there's a miscarriage of justice, whatever. Just,
Right.
It does seem to me that but I'm asking you, do you agree that it offers some clarity where our model instructions may be less than clear?
I think his suggestion may, but without spending more time myself on possibly what I would draft or my office, I wouldn't want to comment any further on that.
Fair enough.
I think he makes it, but I think that what's a little unusual about this is that Mr. Stevenson very helpfully sort of helps us understand why our model jury instruction on this particular thing has come out of a different kind of background. The committee's looking at what the cases say, and the cases really are talking about, as Justice Bartz said earlier, sort of an evidentiary ruling, not an instruction to the jury. And so,
Yes. I understand the issue
Sure.
that my brother is bringing up, but again, in the context of this case, there's a few things that I would like to correct. First, because he just most recently mentioned it, ADA Hagan's comment at the end of the instructions as to what was confusing was just, again, that it felt that the burden of proof was actually even harder on the Commonwealth than that was supposed to be, in that we have to prove all it sounded as if we needed to prove all
All
three,
three.
that he was entitled.
To have
and when
just
he
one,
wasn't.
yeah.
And again, important to note in this case that where deadly force is used, that the defendant's only entitled to the instruction if he had a reasonable belief that he was in imminent danger of death or serious bodily harm from which he could save himself only by using deadly force. 2, that he pursued all possible alternatives to combat, and 3, that the force used was no greater. Here it was in an open street. The only evidence of any threat to the defendant comes from the defendant's statement that he thought that the victim was reaching for something, and that it was the defendant's own statement where he said that he knew this victim, Mr. Jackson, to not carry a gun, that he, that was from the defendant's own statement. And the evidence was that there were 4 shots. The one in the arm is actually, I disagree with my brother, to the back of the arm. The other 3 were to the back. And again, from the location of the shell casings, you can tell that the that the victim was moving, was running away. There's also the spot in the evidence, I've cited to it in my brief, as far as the exhibit showing where the victim falls and then gets up and then continues to run. So it shows the progression of where it started and where the victim ended up. There's no dispute that he was not entitled to a self-defense instruction. He did receive a self-defense instruction.
No, wait, no dispute that he was not entitled?
I'm sorry. It's my position that,
That he was
wasn't
not
entitled.
entitled.
I'm
There's
sorry.
obviously a dispute about that.
Yes, got a little going there. And that furthermore, with the evidence as was presented and as is gone over by both of our briefs, there could not have been a substantial risk of a miscarriage of justice in this case if they were to find that somehow now the model jury instructions were not sufficient to explain that the burden remained with the Commonwealth.
What, I'm moving on to a...
Yes.
I just got to make sure I've got the right case. This is the case where the girlfriend testified about, I've never known him to have a gun or something to that effect.
Yes.
I know it's small potatoes, but
Sure.
what's the justification for that?
Well, again, that came in as that they asked her. This was again to this was used to address the defendant's statement in his statement where he says he thought that the victim was reaching for something, and so the girlfriend was asked, did you see him with a gun that night? She says no. Had you ever seen him with a gun? No.
But what
That's the
difference does
extent
that make to what he thought he saw? Right? He says, I've got it here, and he started reaching in his jacket.
Well, again, maybe that wasn't really the point that I was trying to make, because I do agree with you that that would go more towards self-defense. The point of just why it came into evidence, it wasn't reputation evidence. It was her own testimony of her own observations.
No, it's not, that's not a problem. It's like, what's the relevance of it?
Oh, the relevance.
If it's it's not that it's hearsay or something else. It's what's the relevance?
Well, again, the relevance would, I guess, go to the reasonableness of the defendant's belief that he was reaching for a gun. But other than just relevance, the fact that, again, it was cumulative.
Somebody's reaching it. I think everybody acknowledges that at that time this was a pretty tough neighborhood, pretty tough street. At least from the defendant's point of view, he says, he'd had some prior dealings with this person. So if the defendant, says, I saw him reach into his pocket inferentially for some kind of weapon, the Commonwealth can present evidence that the defendant couldn't possibly have seen that, it was too dark, so on and so forth, but to say that, this is somebody who never carried a gun just seems to me not relevant.
Even if it is found not to be relevant, Your Honor, it couldn't have been prejudicial in this case. And that
Was it objected to?
Yes, it was.
Okay.
So prejudicial. Additionally, I'm sorry, I forgot where the question was before that.
No, that, you've answered my
Okay.
question, so I didn't, I derailed you, so go
Okay,
back to
no,
where
no
you
problem,
were.
thank you. Again, as to the closing argument, the comment that the defendant was trying to hide behind the convenient veil of self-defense did not impermissibly shift the burden onto the defendant. It was a comment on the evidence. Contrary to my brother's assertion in his brief on page 31 that the defendant cooperated throughout, the shooting happened in 1991. He gave his statement in June of 1998 after the officers came to him from a 1996 interview where his name came up. And in the statement, the defendant, there was also evidence, I'm sorry, that the defendant had made threats to Gregory Wingham, who was one of the witnesses that testified to the shooting. And there was evidence that presented that he had, after the shooting, threatened him to not come forward, and also that, that he didn't come forward until that point, that, again, this comment was, as far as his statements to Gregory Wingham, and then also the evidence that came in through the defendant's girlfriend, that he had said that it was over money and drugs at the time. So this is after the shooting, when he's trying to get Gregory Wingham not to come forward. And then when he makes his statement, he starts to talk about self-defense. So that was just a comment on the evidence. Counsel is entitled to argue forcefully for the conviction and to attempt to assist the jury in their task of analyzing the evidence.
Can I ask you a fact question in your brief? I was a little confused by it. On page 7, you're talking about, I think, the evidence at trial, and you say, 2 months later, on July 16th, the police came to speak to Ms. Picard, and she made an identification. I'm trying, 2 months later than what? Was it on July 16th, 1998?
It's 2 months later to the statement, I'm sorry. In June of 1998, 2 months later.
I'm just trying, so she made this identification 7 years later?
Yes.
Okay, not 2 months after the event.
No, I'm sorry, no. I'm sorry, I was referring to 2 months after the defendant made his statement, such as
Okay,
the police
'cause I
had
didn't-
him as the suspect.
Okay.
Any other questions? As far as, again, the comment on justice delayed is not justice denied. Again, this trial took place in May of 2003, and it was subsequent to that the Deloney case came out to say that it is better not to say that. And again, Attorney Hagan is aware of that and has brought that, and that has been brought up in our office. But also to point out that in both those cases, in the case just last week, Francis, and citing Deloney, that in both those cases it was held that it was not reversible error in the context of, again, in this case, it was one sentence at the end of a 17-page closing, and again, the judge had instructed the jury that it wasn't evidence, and also, again, that they were to determine the facts without sympathy. As far as the 12-year delay, it's one sentence where, in context, ADA Hagan is just talking that there's been 12 long years. There's no context to that being referring to that fact that this is on the defendant, the delay. So that's just not in evidence. Unless your honors have any other questions?
Thank you, Ms. Thomas.
Thank you.
Thank you.
All right.